I support the validity of the statement, the Commerce Clause, the secret weapon of Congress. Under the U.S. Constitution, in Article 1, Section 8, Congress is given the power to regulate international and interstate commerce, as well as trade with Native American tribes. While the word commerce can be interpreted in many ways, from the exchange of goods or services to the general interactions between states, Congress has been given a substantial influence over the transactions between states and with foreign nations. Since its establishment, the Commerce Clause's reach has been expanded by multiple Supreme Court decisions. In the legal dispute Gibbons v. Ogden, a case over the operating areas of a steamboat service in New York waters, Ogden argued Gibbons had no right to operate in New York waters because he possessed no New York state license. However, the Supreme Court ruled in favor of Gibbons because he was operating under the federal certification for interstate waters, because he was taking passengers between New York and New Jersey. This decision strengthened the Commerce Clause because it meant it also applied to navigation between states. Furthermore, the Supreme Court ruled Congress's usage of the Commerce Clause was constitutional as long as the commerce involved multiple states. Not only is interstate commerce subject to the Commerce Clause, but also local commerce that has the potential to be involved in multiple interstate transactions. These transactions can either be goods or services. Such an overarching power truly provides Congress with a secret weapon and a great influence on the U.S. economy by extending its reach to local commerce through its federal power. In the past, Congress has used the extensive power to protect the market of specific goods, like in the case Wickard v. Filburn, in order to maintain a specified price for wheat. Congress had put in place production limits based on acreage in order to avoid saturating the market with an overwhelming supply of wheat and consequently dropping its price. When the Ohio farmer Filburn produced over the limit and was penalized, he argued that because the extra wheat he produced was for his own personal use and had not entered the market to be sold, he had not violated the production limit. However, because the limit was put in place to protect the market, and allowing the extra production to take place would encourage other farmers to do the same, the ruling made was against Filburn. From an economic standpoint, this makes sense. Because he would not need to buy wheat due to his own supply, he was therefore affecting the demand for wheat, causing it to drop. If every wheat farmer did the same thing, the overall effect on demand would be a huge drop, and the wheat market price would fall rapidly, therefore counteracting Congress's action to establish a specified price for wheat. The federal power given to Congress in regards to commerce far outweighs the state's power, due to the states being unable to regulate interstate trade, should regulations bar them from providing a service or good in another state, or if the goods or service be against federal regulation. This is an example of the Dormant Clause. An example of this Dormant Clause, in effect, is the inability to have marijuana in your possession when crossing state lines, regardless of the legality of marijuana in either state. This is because marijuana is illegal federally under the Controlled Substance Act. Additionally, possessing it while traveling between states makes it directly subject to the Commerce Clause. When using the broader definition of commerce, Congress also has an influence over the hiring process and financial investing and safety regulations of any entity who potentially participates in the interstate markets, as long as they make decisions to protect overall market conditions, such as in the case Wickard v. Filburn, I believe that while this power given to Congress is substantial, it is in good hands.